dentists focus on the brand and they think it's the brand that's what the consumers want, but the underlying technology is protectable.
Hello, everybody, and welcome to the latest episode of the Raving Patients podcast. As you know, I'm your host, Dr. Len Tao. To begin, I want to thank our sponsors, both the Doc Sites and Dental Intelligence, for their support in putting this podcast on. Today's episode is called The Innovative Dentist, and I'm speaking with a fellow member of the Parkland community. The patent professor's name is John Rizvi, and we're going to be talking again about patents and how to protect things in the dental industry. So Professor John Rizvi is a board-certified patent attorney, adjunct professor of law, and recognized speaker in the field of intellectual property. He has over 25 years of experience in patent and trademark law and was among the first group of attorneys ever to be board-certified as an expert in his field. He is the author of 2 books, Escaping the Gray and Think and Grow Rich for Inventors, both critically acclaimed international bestsellers. The growth of the patent professional law firm has been formally recognized in recent years, and for the past 3 years in a row, his firm has been included in the Inc. 5000 and presented by Inc. magazine as one of the 5,000 fastest growing private companies in the United States. He lives in Parkland. His wife is a dentist in Plantation, Florida, and they've been married for 24 years. They have 5 children. One of which is going to be graduating from Rutgers University in May of 2024. So they have 2 dentists in the family soon. So, John, thank you for joining me on the Raving Patients podcast.
Yeah, it's a pleasure, Len.
I see you on social media a lot. I see all of your posts. You're very active on social media. You've done a terrific job of branding yourself in the area. And obviously you've seen your firm grow over the years. So I want to talk a little bit about how patents relate to the dental industry, because, you know, there's people who reach out to me. As you know, I started my own review software. I didn't patent it. I didn't do anything with it. I sold it to another company, and we've grown from there. But there are dentists in the industry, and I get a lot of it now because of what I've done throughout the years. So I have people send me their ideas and ask me my thoughts on it. So talk about how your space of patents relates to the dental industry.
First of all, it was kind of an accidental niche practice area that my firm developed. My wife's a dentist. After we were married, I started going to dental conferences with her, and I quickly found out the ones that I like. The clinical ones, I think, are the ones I try to avoid now. But the ones that, like where I met you at Delivering Wow, where they talk about business topics and marketing, and that's how I found out about what you do with reviews. And I found that there's a lot of dentists, they're so incredibly humble when they come up with new ideas, because I think the way what you guys do on a day-to-day, your day in your life of your practice, you're a lot of times just creating things from figuring it out, like doing it live right there in front of a patient. You know, the textbook and the education helps, but a lot of it is just, dentists end up thinking that's par for the course. That's part of what dentists do. And when you take that and you come up with some process or system that works for your patients, they don't really think about, hey, I want to stop other dentists from doing this. In fact, the complete opposite. The feeling is, well, let me go and teach everybody this marvelous process that I've found, or this tool or some kind of adaptation of something that I use that's made my practice better. It's completely very different from how lawyers practice and view their practices and general business. Like when if we find out a new way, innovative way to grow our law practices, it's a very competitive field, and you won't see lawyers out there talking about it. They'll typically protect their IP and sell it. So I found that huge distinction. It was almost eye-opening when dentists was like, "Oh, I can protect that. I can be the only one to do that." And a lot of that has started changing because there's, things like Invisalign, and dentists are starting to see that, hey, wow, there is proprietary protection available for their ideas. So hopefully, I don't know if that sets the tone, but that's where I first began my involvement. And then we've had a lot of dental clients over the years, dental laboratories. The Inman aligner, Don Inman's a client of ours. He's revolutionized dental aligners, and it's just been, it's been a marvelous kind of specialty within patent law.
Got it. So, no, look, like I said, I get a lot of ideas that are sent to me for thoughts on whether they think it's I think it's a viable solution, because whether it's software or hardware, I get that a lot. But how does someone know, or how does someone get to know if their idea is worth, in this case, protecting it?
The first step, and I use this example a lot for dentists and doctors because they understand it. So the first step is a patent search. And a patent search is a review of all of the existing patents and published pending applications. First, to see, is it a new idea? Because if it's not a new idea, even if it's a good idea, you can't get protection for it. Like being second doesn't get you anywhere in the patent world. So that's the first thing we do. It takes about 10 days to do a patent search. And that's where my legal opinion on patentability comes in. Now, that's not whether it's a good idea. That's just, hey, can I get you protection for this? Is intellectual property protection available? And that's the first step. If it is available, now you have to look into, from a commercial viability standpoint, is it a good idea? Can it be done at a reasonable cost? Is it something that others would be willing to pay for? In the case of dental techniques, is it a shortcut that provides some advantage, some benefit? From the patent office's standpoint, they're looking for different, but different isn't necessarily better. So is it a good idea? You want to look at not only is it a different way of doing it, but what problem does it solve? What advantage does it have over what's out there? And that sometimes that advantage could be cost, it could be time, it could be durability, longevity. Like you have a solution that is better for a patient in the long run. Something will last 15, 20 years as opposed to 5. That's a huge advantage. So you want to look in those terms.
Gotcha. It's interesting. I'm a big Shark Tank fan, and I watch Shark Tank a lot, and they talk about products being patentable, and do they have a patent for their product? And some have, tons of patents. Other people are just in pending patent status. So it's interesting to see, and listening to the way the sharks talk to them. It's like, there's one aspect of their device or whatever they created that is different than anything else. And that's the part that they're able to patent. So I find the whole concept of this really interesting, because I'm a big Shark Tank fan. I hear about it on Shark Tank all the time. So why do dentists overlook when they have some unique innovation and fail to protect them? Because obviously that's a big deal. Is if you have a unique item or a unique process, you definitely want to try to protect it. Why do dentists not take a look to whether something is patentable or not?
I think more than others, there's this feeling among dentists that something has to be difficult. Like a new idea, it has to involve a lot of work, a lot of trial and error. And if it doesn't rise to that, they think of it as just an obvious change, an obvious difference that anybody could come up with. Let's see real quick if I can find. Oh yeah, here's an example of a patentable idea. It's fairly simple. I mean, it's clearly not dental related, but this cardboard sleeve is not rocket science, right? It's not a cure for cancer. It's not something that took a lot of trial and error. Jay Sorensen, the inventor, had licensing royalty payments of over $1 million a year for the life of the patent, which is patents are good for 20 plus years. And most people would not look at this, and the word invention doesn't really come to mind. This is just my coffee cup from this morning, but here's a Post-it note. I mean, here's paper with removable glue. 3M's made over $1 billion from this patented idea. Simple ideas that are not difficult. Like, when I was growing up, ketchup bottles were all made of glass, and you had to turn them upside down and knock the ketchup out of them. The change to a squeezable bottle with a nozzle on top and simply reversing the label so that when you go to, it's just the human mind, when you go to put ketchup back in the cabinet or on a countertop, if the words are upside down, you turn it around. And that's part of the patent that Ron Brown patented, that bottle design, and sold it for $13 million. Now, is it rocket science? I've switched the label around and I've made the bottle squeezable. He didn't invent the squeezable bottle. He didn't invent a label. Putting a label upside down is not what some would call, brilliant. But patents are all about the combination of existing technology that provides an advantage. So there's clearly an advantage there. And that's true with 90% of patents are combinations of things out there. The carbon monoxide alarm that opens the garage when the carbon monoxide levels are too high. that's a marvelous, beautiful product. It saves lives, but the inventor didn't figure out the carbon monoxide alarm. They didn't create the transmitter or the receiver for garage doors or the remote, but they just realized that, hey, sounding an alarm is not going to help somebody if they walk into their garage and their car was on and they faint. We need to do, or calling the police is not going to help somebody, or the fire department. Why not just open the garage and let the fumes escape at the same time? I think that's the biggest obstacle that dentists have, is they have this advantage and they literally look at it like, what's the big deal? My fingers were too hot, so I put a cardboard sleeve over this cup, or and they don't see a patent attorney because they're embarrassed to, and they're embarrassed in front of their peers. They're like, I'm going to patent this, but every other dentist could have come up with this. Sure. I mean, every engineer in the country, if presented with, okay, come up with ways to prevent your fingers from getting too hot that doesn't waste paper, probably a lot of them would come up with this. The difference is the inventor that pursues protection.
That's really interesting. What, just out of curiosity, I know you mentioned the Inman aligner. What other, and it doesn't have to be things that you have necessarily dealt with, but what other things in the dental industry would someone find interesting that it was patented or it's known and it was also went through a patent process?
Oh gosh, probably off the top of my head, it's hard, but pretty much anything branded, where you see a trademark associated with it. The trademark's a lot more visible because you'll see the R with the circle around it. But if you actually pick up the product, go to the website, you will find that there's a, the patent covers the underlying technology. The brand, the trademark protects the branding. And sometimes it's a combination of both. Like consumers would, they look at, they bond with the branding. Like there's a drug, the purple pill. They don't, that might be patented. I don't know offhand, but they know the word, the purple pill, and they go to their doctors and ask for that. And dentists find this. So anytime you have patients coming in asking specifically for, do you guys do Invisalign, or do you do whatever? Dentists focus on the brand and they think it's the brand that's what the consumers want, but the underlying technology is protectable. And again, I hesitate when I use the word technology because this is technology. So it's not necessarily it's something super complex. It could be an incremental change.
Got it. It's funny. You mentioned Invisalign. Invisalign's patent ran out. And when the patent ran out, all of these other companies were able to find out what was in their aligner. So they had to switch to a different aligner that they patented again to maintain their competitive advantage in the industry. But once their patent expired, all of these other companies came out with aligners, and they have so much competition now because of that. So that's interesting to see as well.
Yeah, same thing. I'm older, so I remember when making a photocopy was referred to as Xeroxing something, right? Can you go and Xerox this? The exact same thing. Like at one point, Xerox had a 20-year monopoly on the copy machine, and that just became the general terminology. So the same thing has happened in the dental industry with Invisalign, right? When a patient asks for Invisalign, are they really asking for that specific brand? Because the patents now run out, but they're not. That's just become the general term. Kind of like Kleenex is kind of becoming for a tissue, right? If you say, do you have a Kleenex? What's somebody going to say? No, I don't, but I have this.
Same thing with Zoom whitening. Zoom whitening was with Discus was the brand. Everybody wants Zoom, but now obviously there's so many other types of whitening out there on the market. Zoom isn't, but people call it Zoom still, and right. That's because that was the leader that was the first thing that came to market back then.
100%. And then so you want both. Like that's another thing for dentists to understand is you want the brand protected for a new innovation, because that's going to outlast the patent, especially if it ends up getting a following. But then you also want the underlying technology, because in the beginning, until you've built a really strong customer base, the name is not as valuable as the underlying idea, because especially a well-funded dental competitor could come out with, a different name and take your technology. So you want to get both. You want to get the idea protected, but then also the brand. And going back to use an example everyone would understand, like this is branded as a Post-it. So 3M has the brand for a Post-it. The patents now run out, but the brand is so incredibly valuable. And I'll challenge you, like right here on the air, like without referring to it as a Post-it, if you went into an Office Depot or Staples, what would you ask for if you wanted this? Like
you ask for a Post-it.
You'd ask for a Post-it. It's hard. It's so difficult. But you could say removable yellow sticky note or something, and it's a mouthful. But that's how valuable the brands become over time. Because people are like LoJack, for example, the anti-theft device for vehicles. They were the first anti-theft device. They had a patent on it. The patent's now run out. But if you want something to track your car in case it gets stolen, you're still...
Call it LoJack. You call it LoJack.
Yep.
Yeah, it's really interesting to look at it from that perspective. I don't think we look at it like that normally. But yeah, those patents that are run out are very heavily branded, and you refer to it by the brand, even though that's not necessarily the only one on the market that's available. You walk into Staples, Staples has their own brand of sticky notes now. It's not called a sticky note would be another term you can use, but I call it sticky notes. But same thing. But someone will go in and say I need Post-it notes because that's the brand that's established there. So I'm curious. You mentioned technology. You mentioned or like the sleeve. You mentioned physical types of things. What about dental processes? Someone that creates something new, is that something patentable that's just a process versus a piece of technology or a piece of equipment or something like that?
Yeah. Oh, 100%. So there's 4 general categories that you can get patents on. The first is a machine. So that's straightforward. A composition of matter. So if you have a new material that you put together and a process or a method. And most software, that's how software is protected by, it's a process or a method. That would be the right way to protect software, but not necessarily even software, even a series of steps that have to be taken to conduct a certain dental surgery. I mean, a new method of that's better for doing a root canal. You write down those series of steps, and then as a patent attorney, I look at it and I try to work with the dentist to figure out which of these steps are optional, which of these steps, if you skipped, could a competitor still do. And they identify the skippable steps, and then we bring it down to like the bare minimum. And that's what I want to get protection on, because now no competitor can follow this process no matter what. And you can protect it as if it's an actual process or if it's software, because that's all software really is a series of steps.
Got it. This wasn't a question that was on our list of speaking points, but I'm curious. Talk about, you always hear that people don't do patents. They don't protect themselves because of the cost involved in getting a patent. So what is the cost of the physical patent part of it? And obviously you're paying for legal fees and lawyer time and those types of things. So can you just run someone through that? Because that's something I'm not aware of is kind of the cost involved in making something patentable.
Right. So, I mean, the first cost, and again, this is, I love when dentists ask about this because they can relate to it. The first cost is like you would have like a full set of mouth x-rays, right? There's a certain cost associated with that. You have to do the x-rays to be able to advise the patient what the next step is. So for us, the x-ray is the patent search, and that's roughly about $1,500. And that's to go through the 10 million plus existing patents and tell you if what you have is new. Once that's done, then there's 2 types of patents, general types. One is a design patent, which is protecting just the look of the idea. And for most dental patents, that's not what really protects them. Design patents are great for sculptures and statues and things that are aesthetic, because for the most part, dental technology is in your mouth, and the key is not to be seen, right? You're going for the opposite, like it's not to be seen and to look like natural teeth. So design patents are not what you want. A utility patent is the other type. Design patents, just by the way, is about $3,000-$4,000 to protect the look. A utility patent can be anywhere from $10,000 to $15,000 in terms of the investment to get the patent on file.
Does that include your legal fees and stuff that are involved, the time you spent?
Oh yeah, that's everything.
So that's all in. That's all in.
The government fees, there's a government filing fee, that's everything. Drawings, you have to have detailed drawings showing the idea. So all in, it's about $10,000 to $15,000. It's not a tiny investment, but it's also not what a lot of people have this view, like I've got to be Microsoft or Google or Apple to get a patent. That's not the case. I mean, most likely the patent's less than, everyone has a vehicle, a car, like the patent's less than, probably half the value of most people's vehicles.
But it can also make you a whole lot of money by investing that in the beginning, because if you patent something and you own the patent and you want to license it and nobody else can do it, that's where like you talked about, the couple of things you talked about, those are licensed products. They're not really, the sleeve is being licensed to the various companies. Starbucks is paying to use that product. So, it's all about licensing deals there. I get that process there. So And what is the length of time it takes for someone to get a patent? I mean, I'm sure it takes months or years sometimes, I hear.
Yeah. So, and that's another myth or another concern that it's going to take so long to get the patent that by then the technology is going to change and it's going to be moot. Well, what people don't realize is that patent pending is the critical date that you want, not, the patent being granted. Yes, that does take 2 to 3 years, but the patent can be filed within 12 weeks. And once you have the patent on file, you can begin sales, you can start marketing, you can start speaking to investors, have prototypes made. You can pretty much do anything. And I have other attorneys that, for example, work in FDA approval law, and they're envious, and they say, you know what, my clients can't do anything, can't make a cent until they get FDA approval. Whereas once you file the patent in 12 weeks, you can start selling. Your clients can sell the idea. You can license the idea. A lot of products are licensed well before the patent is granted, because if you want the newest, freshest ideas, companies today almost always have to license them while they're pending, or else they're getting an idea that's 2 to 3 years old. And an analogy to baseball, right? If you want you want to recruit the best players, they're starting to go younger and younger. You can't wait until they're playing in college, because at that point they might be out of your price range. So if you want to get them early, start recruiting players from high school, and that's what colleges are doing. They're starting to give scholarships and get kids in early instead of waiting.
Got it. That makes a whole lot of sense. So you have a new book coming out. It's called Branding the Multi-Million-Dollar Law Firm. So tell us a little bit about this book, but also how it applies to dental practices.
Yeah. So, here's a copy. This is a draft copy. It's not out yet, but if you brand it, they will come. And it's funny. And this goes back to, where I was envious of dentists, because there's no requirement. You don't have, clearly you guys are regulated, you're licensed, but it's nothing similar to what us lawyers have as attorneys. Like, as an attorney, we have been restricted for years in our branding, rules requiring that the name of a lawyer be in the law firm name. So we would have names like Johnson, Christopher, and Stark, PA, and that would be the brand. And the poor consumer had to figure out from Johnson, Stark and Winston or whatever, PA, like, what does this law firm do? What kind of cases do they want? And it was an obstacle. Only in the last few years have the state bars allowed lawyers to start branding with trademarks, and that's why the patent professor is a slogan I've used for years. But getting back to dentists, you don't have this restriction. So years ago, with my wife's practice, she wanted, Dr. Saba Rizvi, DMD, and I was like, why do you want to do that? Why not have something that patients can remember, find it easy to refer other patients to? And I had My Dentist for Life, and I suggested, I said, why don't you brand as My Dentist for Life? And she goes, oh, well, this was years and years ago, when a lot of dentists are now starting to brand with a name. And I think this is the big franchised corporate dental offices are really what has woken everyone up to this, because they don't use individual dentist names in their brand. So that's the trend. Dentists have now jumped all in with that kind of branding. And I'm now, with my book, kind of telling there's a lot of lawyers still resisting the move to trade names for their law firm. And they don't realize that the bars have eased up on the restrictions, and they now are permitted to do that. You don't just have to have it as a slogan. But dentists have generally, like lawyers, we've been way behind in the marketing and business side of practicing dentistry and practicing law than other professions. My daughter's she's got one more year of dental school left, and she has a course that's, the stuff it's teaching is so practical. And my wife said they never taught this when she was in dental school. Like, the questions were like employee scorecards and how do you tell productivity. Like this is not what typically is taught to dentists, but it's now being taught. Law schools are way behind there. But my wife was able to get the telephone number 954 My Dentist, and it's short for My Dentist for Life. In what other field could a generic phone number like that be picked up for literally, I think we found the person that had it. It was an individual homeowner, like non-business, and sold it to us for $500. Like law firm phone numbers are 50, 60, 100,000, up in the millions of dollars for a memorable law firm vanity number. I don't know if I haven't looked into dental numbers now and to see where they're going, but certainly I think it would be hard to really go into a dental practice today and not be tuned in to the business and marketing side of it, because that plays a huge role.
Yeah, I think it's great that your daughter's getting some business acumen in dental school, because honestly, like your wife, when I was in dental school, they didn't teach us any business. I was self-taught from a business perspective. So I want to transition now. And before we give, and by the way, I'm known as the reviews doctor. Talked about a memorable brand. People call me the review. They also call me the bird eye guy, but that's a different situation. But that's what you're talking about with your wife being my dentist for life. And I think that's her website too. mydentistforlife.com. So, let's transition. We'll have you give your contact information and how they can reach out to you if they have any questions in a little bit. But I want to transition for a few minutes to a section that I like to call the lightning round Q&A. I kind of told you a little bit about this. I'm going to ask you some business questions. You'll just real quick answers. You don't have to go into long and drawn out answers. That's not the purpose of this. Very quick, easy one. Just think about the answer and say it. Okay.
Perfect.
So what do you believe is the most common reason for people failing or giving up?
I think not going outside their comfort zone, just sticking with what they've done before.
Perfect. What distracts you the most every single day?
I would say I still have, as the owner of a 50-plus person law firm, I still get distracted by a new technical, fascinating invention. So I'll walk by someone's desk and could spend an hour or so. So I try really hard to say, hey, that's not my role. I'm here as the CEO of the firm. And that's my biggest distraction.
Got it. What is the number one tactic you use to stay organized?
My iPhone. There's so many apps on it, my notes, and I don't know how we did it before not having phones.
I agree with that. What habits have helped make you successful?
I think really honing in and tuning everything else out. Like when I started my practice, a lot of advice I got was are you sure there's a practice that can be based just on patents? You're calling yourself the patent professor. But what about simple divorces, corporate work, tax work that all lawyers do? And I made a decision, I don't like that kind of work, and it's paid off. Got it.
Who do you look to for advice or mentorship?
It's funny. I've actually looked outside the legal circles, and I look at doctors that are doing well. I look at, and that's why I ended up going to these dental conferences with my wife, because you see dentists that are really business minded, and you bring back new ideas that I can apply to my law firm.
How do you distinguish yourself from your competitors?
The biggest thing is I try, and that goes behind the brand, the patent professor, is when I teach at law school, I try to make the law relatable to third year graduating law students. And I try to take difficult concepts of patent law, and instead of going into doctrine and legal terms, use things like a sleeve and a cup and carbon monoxide alarm and the examples. You said not long drawn out answers, but that's one that I've got I could speak for 10 minutes on that.
Sure. When you were a kid, what was the first thing you wanted to be when you grew up?
So it's funny. I want to take this cubical Rubik's Cube and make it round. And that's what kind of got me. That was my first kick in the gut, is after spending years sketching it out and drawings. And I happened to see that at this toy store called KB Toys, and somebody else had come up with it. So that was a kick in the gut. I went on to become an engineer, and then who knows where life would lead, and then eventually became a patent attorney.
What book have you read multiple times and you recommend someone else read as well?
I would read Think and Grow Rich by Napoleon Hill. It's a classic, one of the best-selling all-time books. And that's one of the two books of mine that you've mentioned. Is I've done a derivative work, Think and Grow Rich for Inventors. So I love Think and Grow Rich so much, but I took it and related that book specifically to bringing a new product to market.
Got it. And last question, this is a difficult one. If you started a lemonade stand tomorrow, what would the lemonade stand be called?
I would definitely try to use sour but great, or something like that. Something that's catchy, try to avoid use of the word lemonade in it at all, because that's just hint at what I'm selling, but not say it directly.
Got it. Perfect. Those are really good answers. Thank you so much. So, John, if someone's listening to this podcast and they have an idea, they've thought about doing something, but yet don't know what to do when it comes to making it patentable, how do they reach out to you? How do they get your information about your books? Talk to the audience about that.
Our website is thepatentprofessor.com, and my handle on almost every, Instagram, Facebook, TikTok is The Patent Professor. So it's really easy. If you go to any social media platform, type in The Patent Professor, or go to our website. Even our phone number is 1-866 Patent Professor. Easy to find. And we have a group on Facebook called the Inventors Mastermind. So it's a free group, and I moderate that group, and I talk about different concepts of inventing all the time.
Perfect. Well, this was really informative, really enlightening to someone who has kind of, deep down inside, love being an entrepreneur myself. So I really appreciate you spending some time with me. Guys, if you like the episode, please share it with your colleagues. Please let a colleague know if you know they're trying to come up with an idea to reach out to John as well. And just to remind people, I'm having an event called Supercharge Your Dental Practice. It's down in Delray Beach, Florida, September 29th and 30th, 2023 at the Opal Grand Resort. It is a business and marketing boot camp, no clinical. You can go to superchargeyourdentalpractice.com. You can check out some more information there about it. To save an additional $100 on registration at the event, use the term raving, as in raving patients, RAVING, and that will save you $100 on registration. I want to thank the sponsors again, both the Doc Sites and Dental Intelligence, for their support. And John, thank you so much for joining me. And as we end all of my podcasts, remember, your reputation matters. Until the next episode, thanks so much for joining me, and we'll talk to everyone soon.